Hello friends, in the last lecture we have seen in the subject juvenile delinquency the various factors or various determining factors of juvenile delinquency that belongs to differential association, anomie, economic pressure, peer group influence, poverty, then gang subculture and class differentiation like this. There are certain other factors also responsible for the delinquent behavior of the child. Now we will take the second part of this juvenile delinquency, unit 2, that social and judicial contribution. So judicial contribution that relates to social action litigation concerning juvenile justice. Then salient features of the judicial decisions. There are certain cases which are decided by the Supreme Court, and after that we have taken certain good steps for the betterment of the juveniles, and a role of legal profession in juvenile justice system. So from enacting to deciding the cases and taking certain good decisions in different cases, it is most important part of the legal profession to prevent and protect the juveniles delinquency. Now, the first of all, we will see that there are certain social action litigations came in front of the Supreme Court in India. But let us have a brief on the Juvenile Justice Act 1986, which was repealed in 2000 as Juvenile Justice Act 2000, Prevention and Protection of the Juvenile. The Juvenile Justice Act particularly having the objectives that to lay down a uniform framework for the juvenile justice in the country, so as to ensure that no child under any circumstances is lodged in jail or police lockup. Then it spelled out the machinery and infrastructure required for the care, protection, treatment, and development and rehabilitation of the various categories of children coming within the purview of juvenile justice system. Then it set out the norms and standards for the administration of the justice and disposition of the cases, and to take the care and protection of the juveniles, making investigation, prosecution, adjudication. So these are the objectives which was also enhanced in the Juvenile Justice Act 2000 and then 2005. Then the Act also constituted certain special offence in relation to the juvenile and provided punishment for them. So the punishments in Juvenile Justice Act, they are not like hardened criminal punishment, but they are taking care of the juveniles and to restore them back to the society as a good citizen after he stays in the observation homes, remand homes, or care homes for them. So the Juvenile Justice Act, Care and Prevention of Children Act 2000 also aims for the same things. Now let us see that how the trial of a juvenile in conflict with law is held by Juvenile Justice Board, which has to consider in the issues in respect of the age of the juvenile before proceeding with the trial. So whether the person before it is a Juvenile Justice Board is within the prescribed age of 18 years or not, that has to be determined first of all. And for the purpose of determining the age, the relevant date is the date on which juvenile is brought before the board for the inquiry and proceeding. That means sometimes it becomes issue of the discussion whether the child should be treated as a juvenile or whether he should be treated as a mature person in the eyes of law. As you all know that in the case of Nirbhaya, that rape case in which two juveniles were indulged, and at that time it was a demand from the society at high level that they should not be treated as a juvenile only because of they are lacking the age of 18 years and because they have occupied the maturity of understanding, knowing the effect of their crime. So that time Justice A.S. Verma committee has to make amendment in the criminal justice system. So Supreme Court in Devki Nandan Dayama versus State of Uttar Pradesh. One case, that Devki Nanda Daima versus State of Uttar Pradesh. The Supreme Court held that the entry in the school register as to the date of birth of the student is admissible as evidence to show whether the accused is juvenile or not. So here the Supreme Court held that the record of the school that will be sufficient to make evidence of his birth certificate. The court further clarified that in case of the difference of the date of birth between the school certificates and medical certificates, the date mentioned in school certificates should be taken as authoritative because the certificates of medical officer may be based on mere guess because it depends on the body situation of the person at that time, and body structure of each and every person may be changed from each other. So the school certificate can be the best evidence against its birth proof. Then Madhya Pradesh High Court in the decision in Sunil and Anand's versus State clarified that the court cannot leave determination of age of juvenile entirely on the evidence of juvenile, but it is required to make an inquiry suo motu. Here again, if the child is saying that he is of 16 years but he may be matured than that, or he may not be of that age, so here also again the court or the juvenile justice board should make the inquiry suo motu and should determine the age of such child for the adjudication. In Muhammad Dahoor Mia versus State of Bihar, the petitioner alleged that he was a juvenile below the age of 16 years and under the Juvenile Justice Act 1986, and which was repealed afterward. So the Chief Justice of Madhya Pradesh High Court, that Chief Justice of this State of Bihar, however, did not make the inquiry and also it rejected the view that there should be confirmed evidence of his age before the person should be adjudicated. So this way the legal profession or courts has taken view for the betterment of the juveniles in different cases. So this was the view regarding the age of the child who is in conflict with the law and has brought under adjudication before the Juvenile Justice Board. Now in different cases, how we have to decide whether the child is in conflict with the law or whether the child is in need of law. That also the legal view. In a recent case, Pratap Singh versus State of Jharkhand, 13 years that bench of Supreme Court in considering the question regarding the date of reference to which age of the boy or girl has to be determined, observe that there exists conflict between the decisions of the courts in different states. So again here it was decided uniformly that the child who is below the age of 18 years will be considered as a juvenile, whether he is a boy or a girl. And in this way there was a uniformity between the cases, between all over the cases in the country, that the age of the child should be considered to be below the age of 18 years for the adjudication and for the deciding the case under Juvenile Justice Act. Now the probation officer also plays important role in the juvenile justice litigation, that the report of the probation officer to be made under section 15 of the act to be treated as confidential, and it is the competent authority to take certain action in such case. The appeal against the orders passed by the competent authority after inquiry and proceedings in respect of juveniles in conflict with the law or the child shall lie to the sessions court, and the time limit prescribed for the appeal is of 30 days. So in this way you can find out that how the legal approach has been taken uniformly in the juvenile justice. Now let us see the trial of the child or juvenile under the CRPC, how that affects. How does it affect whether the trial has been taken under the Criminal Procedure Code or the reputed Juvenile Justice Act? So the procedure to be followed by a judicial proceedings against a child or juvenile offender as laid down under the Children's Acts when it was in force, and the Supreme Court finally ruled out this that the child shall be tried under the provisions of Children's Act in certain cases when there was no Juvenile Justice Act was enacted. About the grant of bail to the juvenile. In a case, Rahul Mishra versus State of Madhya Pradesh involved the consideration of grant of bail to a juvenile delinquent. In this case, the accused, a juvenile, was charged under Section 147, Section 294, 452, 323 and 506. Part 2 of 307 and 300 of 2 of the Indian Penal Code, and it was proved that the appellant juvenile under the age of 16 was present at the spot when the crime was committed, and therefore his bail application was rejected. This deciding the question of grant of bail to a juvenile, the High Court in this case observed that normally juveniles should be released on bail, but bail should be refused when the grant of bail itself is likely to result in injustice. That is, when it appears that his release on bail is likely to bring him into the association with any known criminals or expose him to moral danger, or release would defeat the end of the justice, then it can be rejected. So this is what the rule that the bail should be granted to the juvenile, and exception that if there are certain other factors which may defeat the law, then such grant of bail should be rejected. What is meant by the neglected child? In a decision Supreme Court given in Lakshmi Kant Pandey versus Union of India, what is the factors that deciding neglected child? So in this judgment under the Children's Act 1960, prior to coming into the force of Juvenile Justice Act of 86 and 2000 and another, the Apex Court held that the operation of law in consequent to Juvenile Justice Act, the juvenile courts under the earlier Children Act would no longer deal with the matters of neglected juveniles, and the welfare boards constituted under the Juvenile Justice Act shall be appropriate authority to decide such cases. The alteration that be operative from the 1st September of 1990, and that means those who are neglected child, orphanage, or those who are wandering, who have been abandoned by the parents, so they should not be tried against the Juvenile Justice Act, but they should be taken care by the Juvenile Justice Welfare Board, and they will be treated as the neglected child or a child in need of the law. Special procedure of the Juvenile Justice Board. There are certain procedures that has to be taken by the Juvenile Justice Board for the betterment of the juveniles. That procedure followed is the proceedings against juvenile offender under the Juvenile Justice Act 2000. differs from that of an ordinary criminal trial, and therefore it can be highly termed as a special procedure in view of the considerations taken into. The proceedings cannot be initiated on a complaint from a citizen or a police. The hearing is informal and strictly confidential. The juvenile offender, while under detention, is kept in separate observation home. Then the trial of the juvenile in conflict with law is usually conducted by the lady magistrate, specially deputed for this purpose. The procedure followed in the trial of juvenile in conflict with law being informal, he has no right to engage the services of a lawyer in this case, and no appeal lies against the orders of acquittal made by the Juvenile Justice Board in respect of the juvenile alleged to have committed an offence. An appeal shall, however, lie against the order of the board to the Sessions Court within a period of 30 days, whose decision shall be final, and there is no provision for second appeal. So these are the certain procedures that has to be followed by dealing with the case of the juvenile under the Juvenile Justice Act by the Juvenile Justice Board. Then second appeal is not allowed only because of betterment of that juvenile in conflict with the law. So the empirical study of juvenile delinquency in India also revealed that the fault lies not with the policy, but sometimes the proper implementation of policy is not done, and the Juvenile Justice Act is still having very good provisions, but that policy implementation is not done in a specific way. The certain facts that regarding to the juvenile delinquency in India are that large number of juvenile delinquents are found not to be acting their own, but they are exploited by the others. This is particularly true with the offences relating to delivery of illicit brew and liquor and immoral traffic in human and girls. The juvenile delinquency in India is typically a male activity, and female contribution is less than compared to the male contributors of juvenile. Then juvenile delinquency is not a nationwide phenomena, but it is in the metropolitan cities or where the literacy is not at that particular rate. Then the study also shown the observation that there is a little scope for delinquent gangs in India, and by and large the Indian society does not seem to be generate conditions which repel the youth from the home to the street. And the juvenile delinquency in India makes a relatively much smaller contribution to the crime picture compared to the developed countries. So this is what the situation based on the real facts by the survey, and that's why we have a better legal attention towards the juveniles, problems of juveniles. The treatment of juveniles in conflict with law and children in need of care and protection is also based on the Juvenile Justice Act, and it will be that it is the institutions such as observation homes, children homes, special homes, shelter homes, reformatory schools, and the bosters, they are also meant for to climate the prison sentence to children and adolescents under a particular age group. So they are taking care to make the betterment of the children and restore them back to the society. So these are the certain facts that are related to the social action litigation in India related to juvenile justice, as well as we will see some cases in the next lecture. So juvenile justice is not a big problem in India, but sometimes it happens that they are being a victim of the circumstances.